All right. Good morning to everybody out there, and thank you for joining with us today. Today, we have a very, very special show, as some of you may know. So I see the chat's already active, already all out there. That's great. Hope everyone's having a great weekend. And today is a very special day, as you know, a special Mother's Day. And I figured in honor of Mother's Day, we should have a really special show for you. And I worked very, very hard on this. I had to use all of my persuasiveness. It was really a difficult job over this weekend. I worked a lot harder than I usually do. But before we get into our special guest, let's get to our first special guest. As many of you already know him and familiar with him, national trial lawyer Solomon Radner is back with us on Sunday to break down week number 3 in Karen Reed's trial. So here, let's bring up Solomon Radner. Solomon, thank you again for joining us here at Brother Counsel Studios.
Good morning, Brother Counsel. It's always nice to be your Brother Counsel.
All right. Oh, great. Are you excited for today's show? That's what I really want to know.
Of course, I'm excited for today's show. Anytime I get together with you and talk about cases, I'm excited.
And we're going to have some even more special guest, which I think you may know her from around the block, literally. So what we're going to do now is bring on our very own, for the first time, making her debut on Brother Counsel. Here we go. Mother Counsel. Put your hands together for Mother Counsel, everybody.
Thank you. That's very sweet of you.
Okay, so we're going to start off the show a little bit calm down. We're not going to really get into the meat and potatoes of the Karen Reed trial just quite yet while my mother's on. And we just wanted to, Solomon and I both wanted you to be here so we can all tell everybody how important you are to us and how grateful we are that you are our mother and raised us. After all, that wasn't a simple job, understanding that you are the mother of 9 children. So why don't you try to give everybody a little bit of a flavor of what it's like to be married to a lawyer, having 2 children who are a lawyer, and also just general being the mother of 9 children while at the same time you are working really 2 full-time jobs. Give everybody a little bit of a taste of what that's like.
Well, this show is worth being on just to hear you say that.
Oh, I talk like this all the time about how great you are.
That's very sweet of you. Thank you very much. So I was very lucky. I am very blessed. I have 9 wonderful, wonderful children. My house was pretty busy. There's a lot going on. And, the stuff with having all these attorneys in the family means that our supper table discussions are fascinating. We discuss strategy and listening to what Solomon has to say, what you has to say. And so when some of the brothers-in-law come over, they have to say, because they're also lawyers. And of course, my husband, who's just phenomenal when it comes to law and many, many other things. So I'm blessed. Yeah. It's been a very educational, that's for sure, supper table.
Yeah, well, before we jump into a little bit more, I just want to let everybody know that Mother Counsel is only going to be here for a little bit. Only got her for a couple minutes. I was able to pull her away from all the other Mother Days activities that she has planned today. So if you do have questions for her, please put them in the chat right now. I'm going to ask another question or two. Maybe I'll let Solomon ask a question, and then we really want to turn it over to the people here who have some questions for Mother Counsel. So definitely put that in the chat right now in the meantime. But let me just ask you this, okay? I'm sure a lot of people are wondering, being the mother of 9 children, and of course, I'm the middle child. And people were asking me before, who's your mother's favorite child? And I said, she's going to come on the show today, and she's going to acknowledge that I am her favorite child. So now this is your opportunity. Everyone's listening, everyone's watching, and now you can just come clean and let everybody know for good and for once and for all that your favorite child of the 9 children is your middle child, Martin.
I've got Solomon right here, and I don't know how many of the other kids are listening. So what did you – I really can't respond to that question.
Well, we all know that it's not Martin.
The middle child, we had to get down to him. That's very cute.
Okay, well, we have Gwen Garnett.
Got a name.
Gwen Garnett says, Happy Mother's Day. Your children are amazing. So,
Ms. Garnett, you're absolutely right. I'm very blessed, and the kids were, it was easy to have these children. They never gave us an ounce of trouble, and they were good students. Everyone of them is married. They all have wonderful families. The girls they married are absolutely amazing, wonderful, wonderful women. They're wonderful wives, they're wonderful mothers, and they've been a wonderful daughters-in-law to me. And they all have jobs, and they're settled in their communities. I'm really very, very proud of them. Thank you for the compliment. I shine in reflected glory all the time.
Yes, and I'll definitely echo that. Mrs. Martin is just a gem, and I'm very thankful and grateful to my wife and being the mother that she is of our 6 children, understanding how what that takes. And unfortunately, I can't get her on the show quite yet. She likes to stay in the shadows, just like Mother Counsel. But I'm very persuasive, and I could be very persuasive. So I'm glad that you joined us. Here's another Happy Mother's Day, brother's mother, from Amanda the. So let me ask you another question, because I think this is also might be on some people's minds. What you're raising 9 kids. You're very busy. You have certain values that you want to give over to your children. And what would you say, looking back now, that the values that you tried to instill in all of us, whether you were successful or not, is another question. But what do you think that the values that you would try to instill in all of us were?
Well, I would hope that both you and Solomon can answer that question, or else I didn't do a good job. But I mean, you all know the first word is honest, and the second word is kind. We expected honesty, we expected integrity. That if you say something, people will know that you're telling the truth. That if you say something, your word is your bond. You can take it to the bank like your father. You follow in his footsteps. I mean, you and I all know that our story recently is that there was an attorney that we were dealing that your Tati father was dealing with, and he was telling my husband that he could only settle for a certain amount of money, and then unfortunately he sent the email on top of the email from an adjuster, and the adjuster had given him authority for $20,000 more, and from then on you knew that attorney could not 100% be trusted. So I would not want my children to be like that. I would want to know that if my kids say something, it's the truth, and that people know it's the truth, and they are upright, and that they're kind, and they give back to the community. And I've seen that with every one of our children, thank God. And that's also because you have my husband as a role model. I mean, it's just, watch the values continue from one generation to the next. And I'm very blessed, and I'm very grateful.
Yeah, and I also want to say that one of the things that we've learned growing up with you and as our mother, that the most important grade on the report card, after conduct, of course, was effort. And my mother really cared much more about if whether we're putting in our full effort as opposed to what the actual grades were. If we're trying our hardest, that's all that my mother cared about.
Well, I have to say that in that case, there were children I didn't see for years because they were upstairs studying. I mean, I don't know how you and Solomon both did it. You were married, you were holding down jobs, and you were all the other things that you did. You both were skating for charity. You were taking on positions of responsibility. You were studying. You both got awards, and you got positions of honor in your law schools. I mean, again, we were blown away by how hard the kids worked, or your sisters who are in the medical field, and they worked and worked and worked and studied and studied. It's just you will be what you want to be if you work hard enough at it. That's for sure, and you did.
Well, if we would have been smarter, then we would have got into the medical field. But unfortunately, the genes for the grades, for some reason, the genes for that, with the girls. Here's a comment. Favorite child after 9, the last one, Shirley.
Oh, I mean, I hope she's watching so that she can see you say that.
Here's an interesting comment. Mom has 10 fingers and likes each one equally.
My mother used to say that. I'm one of 7 children, thank God. And my mother used to spread out her hands and say, which finger do I like best? When we would
obviously the thumbs.
What'd you say, honey?
Obviously the thumbs.
And this is what from CCL Montoya. Your mom is so young looking. She is beautiful.
Thank you very much.
I bet you want to come back now, more often now.
I to shine in reflected glory as I am, for sure.
Here's a question. Mr. Crosby's orphaned methodology. What's the age gap between oldest and youngest, and how many boys and girls?
I'll tell you exactly. I think it's 16 years, and we have, thank God, 5 boys and 4 girls.
How many grandchildren do you have?
Not enough.
No pressure, of course, to any of your daughter-in-laws.
I'll just let them know that people are asking. But I will say that every family has at least one child. So thank God, thank God.
Yeah,
I will add one more thing, by the way, and
Sure.
that is that there's a lesson that we learned from you, that we all learned from you over and over and over again, that applies very strongly to this case, and that is, don't ever put anything in writing that you're not willing to see on the front cover of the New York Times.
Right. My mother used to
And
say
that's something that has presented its ugly head over and over and over again in the trial that Martin and I are about to talk about. We're talking about text messages and all kinds of things that should never have been put in writing. That's all there is to it.
But especially nowadays with emails, you never know where emails are going to be forwarded to and who's reading what, and you think it's private, and it's not. It's like your father had a case where some woman was claiming to be seriously injured, and she posted pictures of herself on the internet. And the defense counsel found it. And of course, once your father found it, he wasn't going to, represent a fraudster. But you're right. You never know where things are going to end up. You never know who's going to read something. And that is very true. But that's true in life also. You just have to. Agatha Christie, the big mystery writer, always said old sins have long shadows. You never know what you do, what you say. I mean, all the people in human resources, when people come in for interviews, and then they bring up something they posted on Facebook, something idiotic that they did, and it follows you. You just don't know. So it's really even more true today than it used to be.
Yeah. Here's another question: are your children religious, and did they get that from you and their father?
Well, kids, you tell me.
You should know
The answer is yes and yes.
I hope our home was a religious home. God is a presence in our home, and I'm very, very grateful that they are. All my children are religious, and they try to live upright, righteous lives.
Here's a comment, Mommy, from I am not a mother, and my mother is gone. So thank you for inviting me into a piece of your Mother's Day today.
Well, I hope that doesn't mean you're not going to bring the grandkids over later. But yeah, I remember the last Mother's Day with my mother. My mother lived in Cleveland, and we drove in to see her, and I miss her terribly. And I you kids know I quote her all the time, and I'm grateful that I had my mother for as long as we had her. But it's never enough. It's never enough.
It's never enough, and she did live, a nice old age, unlike your father. But still, we know how much she meant to you, and how much you tell everyone who still has a mother with them to take advantage of that.
Call them more, call your grandmother, etc. Nothing. That's true.
Well, I guess we're getting into a little bit, so we're just going to ask another question or two before we jump into Karen Reed. So I know a lot of people came here to hear what we're going to talk about with Karen Reed, but we do want to, respect Mother's Day and give our respects and our appreciation to our mothers. So that's why we're spending a few minutes on
Mother's
the show.
Day is here, so that means you'll talk to me. Oh, no, go ahead.
So I remember when I was asking you about what books I should be reading when I was about 12 years old. And you told me books like The Count of Monte Cristo and The Three Musketeers, A Tale of Two Cities. I think that at that point, they may have been a little bit above my reading level. But, we're talking about books. So why don't you tell everybody what you like to read, what you think has good messages, and, just talk about some of the books that you like to read.
Are you talking for children or for adults?
Adults. I think all the people watching are adults now.
Oh, okay. I mean, I'm really, I'm much more expert on children because I taught for so many years. But I would say, at least Louisa May Alcott always was very strong about stories that give a message or historical fiction. So let's say if you read a Charles Dickens book like Oliver Twist, you'll understand what life was like for orphans, and you get an appreciation of all the laws that we have to protect orphans and to protect people who don't have it nowadays. So I like stories with a message. I like historical fiction. It's an easier way to learn things.
Now that we're on the topic of what your favorites are, what about your movies? What are your favorite movies? And I know that what my sisters would say But now it's your chance to say what your favorite movies are. We're not talking about just the movies that you would spend the entire Thursday night watching, but just lay it on the table. What are your favorite movies?
Well, obviously the ones that are novels, Scarlet Pimpernel. Everybody knows that one. So I like the classics.
What about Pride and Prejudice?
Pride and Prejudice.
Hold it. Only the 1996 BBC 6-part Pride and Prejudice. That was the one that was the truest to the book. The one from the 40s, they changed the ending, and then some of the other ones I don't think are as true to the book as they are. They're more Hollywoody and let's give a cute little ending. So I like movies that are true to the book. That's true.
Yes, I think the entire family knows Pride and Prejudice video by heart by now.
By heart.
Yeah, we can all imitate the different characters' parts. Here's another comment. You are so lovely, and we all want to mush on you. Do you have any musical children? Now, Ma, we only have a few minutes now, okay? So we're going to limit this discussion to about 1 minute and 30 seconds. So if you can get out in the middle of 30 seconds, I'll let you go. Go ahead.
Whoever it is that posted that question must know something about our family. My mother was the music teacher in the school that I went to. We all learned to play piano. I tried with some of my kids. Some of them don't. And we do have children who are very musical, as you know. I have one son that was invited, was a good enough pianist that he was invited to participate in a concerto competition. And a lot of the girls especially play piano, and it's important because that way you have something for yourself, and then also you can give to the community for it. You can accompany a choir. I led choirs, my mother led choirs, my sister led choirs. So music has been a very big part of our home. As you know, singing around the table, it's been nice.
Yes, we're quite a musical family. And that brother is
thank God.
He's a real good pianist, and my mother is a pianist herself, and she tried to teach us all piano. Some of us took it faster than the others, and Solomon and I were more like let's play ice hockey instead of playing piano.
You did with that ice hockey was terrific because you go around the country playing for charity and for cancer organizations.
Yeah.
So that's really a big thing.
Okay.
Are you tired of hearing from me already? You want to get back to Karen?
No, well, I don't. I do want to recognize a few people also. I forgot to mention this. Betty Swallock says Happy Mother's Day, Supermom, love from the UK, and we also have not collision. Today's my husband's birthday and Mother's Day, so that was happy birthday to your husband and happy Mother's Day to you. And then also Jersey Tomato sends $5. So I think we're going to stop it here. We don't want to give people too much because we want people coming back the next time I invite you on. So we're going to move on to the Karen Reed stuff. And we're going to have you back another time to share some more of your advice and wisdom.
That's very, very sweet of you to say that what I'm saying is advice and wisdom. But I'm sitting here just playing with shining in reflected glory. I'm really very, very proud of you. I'm proud of all my kids. But you especially with this program, the way you have always had an ability to break down a complicated topic and put it in an organized fashion, like with the books that you wrote, the law books that you wrote. So I'm very, very impressed that you've taken that now to a level where you can explain what sounds like a complicated matter to people and make it in bite-sized pieces so that they know it. And of course, hearing Solomon's opinions on so many different topics is always something that makes me feel good because, as you know, I always say your opinion is always only as good as the facts you have to support it. And when I listen to both of you and I realize that you've done the research, you know what you're talking about, then when I hear your opinions, I consider them valuable. And I compliment both of you for that. I think it's
well, thank you. We got a lot of that obviously from you because you were always able to make complicated subjects easy. So I remember doing homework with you, and that's what you would do when I would get overwhelmed with some hard math problem. Linda Halcrow is our New Zealand representative. She says it's lovely to see Mother Counsel here, such a lovely lady. Happy Mother's Day. I hope you were thoroughly spoiled today. Well, the day's just starting, Linda, so there's a lot of spoiling yet to come as soon as we're done with the show. Don't you worry. So,
I'm going to get the grandchildren and those cards.
That's right, the cards. I told everybody that all you want for Mother's Day is a mushy card that says how much we love you and that you're the best mother and grandmother in the world. So
that's all it takes. I don't need anything else.
Thank you, Helen Lewis, for the 10 Brother Council memberships. And Ma, we will see you later with the kids, God willing. Okay. Thank you very much for coming on.
Very much for inviting me on. I know that your audience really wants to hear what you have to say about Karen Reed. I appreciate you giving me just a little piece of your show. Thank you very much. I'm going to watch and see what you and Solomon have to say.
All right. Okay. Well, there you go. That's Mother Counsel. And now let's jump into the Karen Reed. So there was a lot of stuff we have to talk about last week. Let's start with, I think, what happened on, I think this was day 10. So this is day 10, and we heard Karen Reed's voice messages that she left that night after she was trying to call John O'Keefe a number of times. Let's pull it up right here. So they went through, this is what was the guy's name again? Remind me of his name.
Talking about Ryan Nagel? Who are you talking about?
No. This is the cop. Who Nick Garino. Okay, here we go. Nick Garino. So Nick Garino was the one who was playing all these voice messages. He got the extractions. So Karen Reed started calling John O'Keefe after she dropped him off, right? So she was calling him almost like a minute and a half later, 12:33. Phone calls were calling in. They were not answering. They're not answering. They're not answering. And it seems like she's just building up frustration. And then listen to the voicemails that she leaves here, okay? And if you have any kids in the room, I would suggest that you get the kids out of the room.
Kindly play the voicemail for 12:37:08.
And I'm just going to slow it down so you can hear it because it's not that long, and I'm sure you want to hear. So that was at 12:37. So Solomon, you heard that one, and then she's not quite done yet. There's a few a.m. There's already gone home. So Wi-Fi. So that she leaves. Let me try to get to the other voicemail. Next voice, which is that she sends to.
Miss Gilman.
John, I'm here with your fucking kids. Nobody knows what the fuck you are, you fucking pervert.
So no one knows where you are. I'm with. Okay, that was another one. Okay. Again, they're home alone. But you saw. Then we get to the next voicemail. Here we go.
On voicemail number 5 is left with voice.
Miss Gilman.
Yeah, it's 1 in the morning. I'm with your fucking niece and nephew. You fucking pervert. You're a fucking pervert. Okay,
Solomon. So you're getting the picture. I mean, these are some of the voice messages that were being left, and these are voice messages that she left after, she left John O'Keefe, and she leaves those voice messages. So the prosecution played those voice messages. I think they're trying to show that she had this real deep anger, and you can hear the anger in her voice that she's really upset, and this could be possibly a motive why she would go and kill him. They must have gotten to some fight in the car. She got really mad. She's leaving these nasty voice messages. She must have run him over with the car. So what's your take on listening to these voice messages, and if this is helpful for the prosecution or for the defense?
I don't think it's helpful at all for the prosecution. In fact, I think that these voicemails very strongly support Karen Reed's defense, and I'll tell you why. These voicemails, to me, sound as though she is angry and upset that he's not home and that he's doing God knows what with God knows who. And this is not the sound of somebody who just killed somebody. Okay, when somebody murders somebody, they don't call up and leave voicemails about how much they hate them. It's just not what they do. Okay, so in this case, if she would have actually hit him with the car, such that the next day she was saying, I hit him, which is what the prosecution's claiming here, it makes no sense that she would call and make these voicemails. These voicemails are, where are you? Why aren't you home? Why am I here with your kids alone? If she just ran him over with her car, she knows where he is. And this is not, just so we're very clear, she's too drunk and too angry for this to be some sort of elaborate plan. All right? So it's not like she thought to herself, okay, I just killed him with my car. What can I do to make it sound like I didn't? Oh, okay, this is a great idea. I'll call and leave some voicemails. There's no way that she was able to think that far ahead. So these voicemails show very raw emotion, and it shows a woman who feels scorned and angry and upset that John is not home, and she doesn't know where he is and doesn't know why he's not.
So you feel that their position here, which is going to be that this is all one big elaborate scheme, And it's not tenable because in fact, they're trying to show how drunk she was at the time. How can someone with being that drunk have this type of plan and carry it out the way that she did? Is
and that angry? The emotion is too raw. The emotion is too real. This is not something that requires any sort of expert opinion. When you hear those voicemails, you hear real anger. You don't hear somebody trying to pretend to be angry. You just don't. She's fuming and drunk, mind you, that he's not home. No, this is not an elaborate plan. This is real, raw emotion because she's angry that he's not home. That's what this is. And that's what these voicemails prove. These voicemails in and of themselves, I think, establish reasonable doubt at the very least. I don't care what else comes in. These voicemails in and of themselves show where her head is at.
And there's multiple phone calls, as we've seen. There's multiple missed phone calls, and then you get these voice messages. So, yeah.
Right. One of them, if she really thought she hit him and she was that drunk and that angry, it would have turned to fear. Are you okay? Did I hit you with my car? Are you okay? Do you need an ambulance? There would have been something like that. But how do you reconcile her hitting him with her car and knowing it? Remember, the prosecution's theory is I hit him, right? So the prosecution's theory is she knows she hit him. How do you reconcile these voicemails with her knowledge that she hit him? You can't. You simply can't.
Yeah. Okay. I mean, what about the fact that maybe she hit him, but she didn't think that she killed him? So she was just, mad. And so she thought that I don't know, I'm going to clip him and maybe he's not going to die, but I can still be mad at him and leave these nasty voice messages because I don't think I killed him.
Does that make any sense to you? I know you're trying to be as objective as possible. Does that make sense to you?
I'm just being devil's advocate here.
I know, but it doesn't make any sense. You can try to be devil's advocate, and I appreciate that. That's what lawyers have to do. But you and I both know that it's an untenable position. It just is. These voicemails help the defense very, very much, and that's all there is to it. Now, the prosecution, to their credit, actually played them instead of hiding more evidence and letting the defense bring it out. But I'm sure we'll get to that more.
Yeah. Okay. So let's move on. And what I want to do now is I kind of want to move backwards. So I want to talk about Buchanan first because he was on the stand for like 3 days. It's pretty fresh in a lot of people's minds. I know I've done a number of videos on this already. I know that I kind of forced you to watch some of the cross-examination because, this was just, I thought, unique. We all dealt with evasive witnesses who don't want to answer questions. But I think this was like really another level. So let's first talk about when he was asking him about who the lead investigator in this case is. And this is something that I keep seeing play out where the Commonwealth is trying, like, for example, Paul Gallagher is trying to say, well, I don't know if Michael Proctor was the lead investigator in this case. And then you have Buchanan saying, well, it's all a team effort. There's a case officer, but not a lead investigator. So what's your opinion about this whole line of questioning? And what do you think the jury's thinking? And like, if you were in that position, like in Alan Jackson's position, like, well, what would you do about this type of witness? And like, just talk about the lead investigator. Like, what do you think that's working on the jury? Give your thoughts about that.
Okay, you never know what the jury's thinking. However, I think that Alan Jackson is doing an absolutely masterful job showing that the police are not willing to concede an inch. Okay, very clearly, every case has a lead investigator. In Michigan, we call it an officer in charge, an OIC. Every case has one. Sometimes cases have two, but somebody is assigned that title. In every jurisdiction that I know of, there is a lead investigator who is responsible for the case. And usually that's the investigator who sits next to the prosecutor during the trial. There's always one officer who's allowed to sit next to the prosecutor that there's no sequestration order for, even though he or she ultimately will be a witness in the trial. So for them to not even willing to concede this, I think costs them a lot of credibility, whatever credibility they may have left at this point. And I frankly don't understand why they're refusing to give an inch. That's all there is to it. If there's a fact you have to concede, you may as well concede it. If you're not willing to concede anything, then you lose all credibility. And that's what I see happening here with the prosecution.
And the more that they fight back on this issue of lead investigator, the more that they keep saying, oh, there's no lead investigator. Like, is there some point where you can just turn to the jury and say, here we go. Give some sort of comment like that. Have you ever done something like that?
So That's funny you're asking that. I know you know that I have done that. I've only done it a couple of times. It's a very risky thing to do, okay? Because the judge may not like it, the jury may not like it, and if you're swinging for the fences, so you're either going to pop out to the pitcher or you're going to clear the bases. So when you go for something like this, you better have the goods. Let me give you an example of what I'm talking about. If you're going to look at a witness that you've already established beyond any question is refusing to answer a question, and you look at that witness and you ask the question and they're evasive, and you ask the question again and they're evasive again, and then you just kind of look at the jury and like almost half smirk and look back on the witness and say, you can tell us the answer, we already know. And I've successfully done that maybe 2 or 3 times. One of the times I did it, the judge, you're not sure how the judge is going to react. Canoni, I'm sure, would lecture Alan Jackson, stop making comments. Okay, fine. And that's really what judges should do when you make a comment like that. But I had a judge one time where I did that, and I was asking this question, and it was a case where my client was framed for a theft. This goes back about probably 13 or 14 years. I was much earlier in my career. It was one of the first 100% innocent clients I ever had. I was terrified. I lost weight. I didn't eat or sleep. It was the most traumatic thing I had gone through at a lawyer at that point in time, was representing an innocent person who was facing prison time for a crime he did not commit. And at one point, the lead investigator was up there, and he acknowledged that he was the lead investigator. And at one point, I had him so dead to rights on a particular issue that I asked him the question, and he didn't answer it. And I asked him again, and again, he just kind of stared straight ahead and didn't answer it. And then I looked at the jury, and I looked back at him, and I said, it's okay, you can answer. We already know. And the judge looked at me and goes, answer the question. It was such a powerful moment. And he ended up getting exonerated, and ultimately we filed suit for him for malicious prosecution and collected a very significant amount of money for him.
Yes, I know. I was involved with that case.
Yes, but this is a very dangerous thing to do. And Alan Jackson has not done it, which, to his credit, smart, because you got to know the judge, you got to know the jury, you got to know what you can get away with. Okay, and there are certain things that Alan Jackson is definitely doing that he's doing despite the knowledge that the judge is going to lecture him in front of the jury, but he's doing it to make a point. And I think some of those points are made very strongly by the little comments and remarks that he makes.
Yeah, so there was actually a point.
I think he's doing an absolutely masterful job with this cross-examination.
There was actually, and this brings me to the point, I know I didn't talk to you about this before, but this brings me to another point where there were certain times where the judge was telling the jury, Judge Canoni is instructing the jury to disregard certain comments that Alan Jackson made, and reminded them of the jury instruction that lawyers' comments and questions are not evidence. And she reminded the jury of that. And it was getting to a point where I said, if this was me as a defense attorney, I would be making a record that I think that you're trying to prejudice the jury against me. You're not doing this to Hank Brennan. I mean, I understand that Hank Brennan's not on cross-examination now, but all the jury's getting from you is they keep hearing from you that reminding you of certain jury instructions to disregard certain questions that I'm asking. You don't have to keep reminding them. You said the jury instruction in the beginning. You said it at the end. It's one thing if something's completely crazy and out of line that you tell them to disregard. Okay, but then listen to what happens next. What happens next is that Robert Alessi was actually asking a question. He was conducting cross-examination, and I think this was on Jessica Hyde. And he kept asking to approach sidebar, because that's one of the ways that Judge Canoni runs the courtroom, that you can basically can't state that your basis for objections, and there's creates a need to continuously go to sidebar. And she said to him in full view of the jury, and the jury can hear this, okay, but this is going to be the last time you can come to sidebar on this issue. And she said that, and they came to sidebar, and then afterwards there must have been some more discussion about this, because I think that there was a certain break. And after the break, Judge Canoni told the jury and tried to explain away, say, don't take any of my actions that, I don't remember her words verbatim, but trying to correct that fact that she was telling Robert Alessi, this is going to be the last time that you can approach sidebar for this. And it almost sounds like she's just frustrated with the defense, and the jury's getting that. And it seems like they brought that issue up in front of the judge, and the judge tried. I know some people don't like the way that she did it, and that it wasn't really sincere, and yada yada. I know. I've seen a lot of comments about it, but at the time, it felt to me like they actually brought up this point where you can't keep telling the jury things and treating the defense a certain way, and they're going to be getting this idea that you don't favor the defense.
Yeah. it's very tricky how to deal with this kind of thing. I don't think the judge should have said that. I think she realized afterwards that it was not appropriate for her to say that. And I think she tried her best to fix it. I did have a case once, and I don't remember if you were there for this one or not, where the judge kept interjecting during my argument, but not during the defense attorney's argument. This was it was a lawsuit, and about how the lawyer's comments you have to disregard. And I didn't think it was appropriate, and the judge actually acknowledged it later. Now, that was a case where the jury came back with, as you know, a multi-million-dollar verdict. So I was okay with it in the end. But judges have to be careful to not do something like that. And look, Canoni, I've told you my thoughts on her. I don't think she should be presiding over this case. I think she's incapable of seeing things the way she's supposed to be able to see them to judge a case. I think that there is certainly an appearance of bias, which is all you really need for a judge to ultimately be disqualified from a case. That said, I don't think she knows that she is biased. Okay, I think if she knew that she was biased, she would disqualify herself. I don't think she's acknowledged to herself that she's not able to preside over this case fairly, and that was something that was so glaring that even she understood, I need to correct this, and she did, to her credit. There's going to be other things I'm going to tell you, and I'm sure your viewers are not going to be happy that I'm coming to her defense at all. But there's plenty of things that she's doing in this trial that I think are completely inappropriate. This was one thing that she did that I thought was well done. So good for you, Judge Canoni.
All right. So here's a question. Since Yuri claimed Proctor handled the investigation with integrity, I mean, that was one of the questions that he was asked. And remember, this is a real problem for the Commonwealth because Proctor was dishonorably discharged. Okay, he was fired for the actions that he took in this case, for the conduct that he had in this case. So one of the questions that Alan Jackson asked Yuri Buchanan on the stand was, do you think, as his supervisor, that he conducted this investigation with integrity?
Right.
And he said yes. So,
well, he didn't say yes. He spent 10 minutes not answering the question, and then eventually he said yes.
Right. Right. That's how he answers every question. But
and it's funny. There's a jury instruction that every judge reads to every jury in every case, and it basically says to consider the credibility of a witness. You should consider whether they were making a genuine effort to answer the lawyer's questions, or if they were being evasive and argumentative. And you and I have heard this instruction 100 times. And what I like to do in my trials is I like to find the most argumentative witness that there is, and I like to refer to it as the so-and-so instruction. And then I actually put that instruction up in my PowerPoint, and I show it to the jury, and I read it to the jury. Was he being evasive? Was he trying to be honest? Was he trying to answer the lawyer's questions? Was he being argumentative? And then I just kind of look at the jury and say, who comes to mind when you look at this instruction? Now, so far, I would call this the Buchanan instruction, okay, in my closing to the jury. It's entirely possible that by the time we get to the conclusion of the trial, there's going to be other witnesses that are much more strongly going to be referred to as this instruction. But that's something that I like to do because he's so argumentative and he's not willing to answer anything. Like that question that you just referred to. Did he do this case with professionalism and integrity? And I forgot exactly what the verbiage of the question was. He didn't answer it for the first 10 times it was asked.
Right. Well,
first and then finally, and then finally he answered yes. But it took a while to get there, if I recall correctly.
Yeah, I mean, that's how every single question is being asked and answered. But anyway, here's the question by Nikki. Since Yuri claimed Proctor handled the investigation with integrity, does the defense have a chance to get in Proctor's texts through Yuri, even though Yuri claimed he doesn't know what the texts say? Well, they already got in some of the text messages that Proctor wrote. They got in some of those text messages that he was looking for nudes, no nudes so far, and I really hate that man. They did get some of the text messages in, but I would assume that they're going to get the rest of the text messages in as well. But here's another question, Solomon. I know people are talking about this, and people have said that Turtle Boy reported that Proctor is not going to testify in this case, which to me just boggles my mind. Because if I was the defense, I would call Proctor. Of course, I would call Proctor. So I don't know, I don't know where this is coming from. Maybe there's some inside information. Maybe there's some sort of stipulations or secret agreements between the prosecution and the defense. But can you imagine a world where you're defending this case and you got this guy who was dishonorably discharged for the actions that he took on this case, knowing what the text messages say about leaky blue knot and all that stuff? if you're the defense attorney, would you ever agree not to call him as part of your case if the Commonwealth doesn't call him?
That's a very good question. The short answer is no. I would absolutely want to call him as a witness. There could be ways that I could be persuaded not to if I'm the defense. For example, if the prosecution is willing to give me a stipulation that I'd never get out of him himself, then I could conceivably see myself not calling him as a witness. But it would have to be such a strongly worded stipulation that there's no way the prosecutor would ever agree to it. Like, for example, if the stipulation were that he's dishonorably discharged and he was terminated for corruption and he can't be trusted and everything he said was a lie, then I'd be okay with that stipulation. Okay. But which sane prosecutor would allow that to be stipulated to? The only way, I mean, look, is there some theoretical stipulation that Hank Brennan could offer in exchange for this guy not being called? I guess maybe. To answer your question with a very simple answer, I don't see how this case possibly proceeds without him being called as a witness. Again, I'm digging deep here. Maybe he's going to plead the fifth. And if he acknowledged ahead of time that he's going to plead the fifth, it's possible that what would happen is they would call him not in the presence of the jury. And this is going to be a jurisdiction by jurisdiction determination. If they call him as a witness, not in front of the jury, he pleads the fifth. And then they make a stipulation that they called him as a witness and that he's not going to answer any questions because he's going to plead the fifth. That's the only, realistically, that's the only way I see this happening. But,
and then if that happens, Solomon, let's just play with your theoretical for a minute. If that happens, let's say he does plead the fifth, then I guess the defense would not be able to use his silence against him. You know, I know in a civil case.
No, 100% wrong.
Oh,
so the way it works is a criminal defendant's silence cannot be used against him or her. Anybody else's silence in any other case can be used against him or her.
Okay, there you
go.
go.
Let's say a civil case where somebody committed an assault on somebody. Okay. And during the civil case, there's a deposition and say, did you punch so-and-so in the face unprovoked? I plead the fifth. That cannot be used against you in a criminal case. In a civil case, it can. You're allowed to argue to the jury, he pled the fifth. That means he knows he did it. So in a case like this, where it's not the criminal defendant, it's one of the officers, you would absolutely be able to argue to the jury, he knows he's going to lie. He doesn't want to commit any more perjury. He doesn't want to commit any more corruption. That's why.
You could argue adverse inference, basically to the jury.
Adverse inference is a very specific legal theory. It basically comes along with a jury instruction. I don't think you're going to get a specific jury instruction out of it, but you can definitely argue that they can adversely infer from his pleading the fifth that he would have committed a crime had he answered the questions. Adverse inference is a very specific legal principle. It has to do with jury instructions.
Right.
It's typically referred to as the adverse inference instruction. I don't think you would get that here, but you are allowed to argue that they can infer adversely.
Right. So basically, as long as you're not the criminal defendant, then pleading the fifth is not going to be able to prevent the defense attorney from arguing to the jury that, hey, this Proctor didn't testify, he pled the fifth. Why do you think that is?
Right.
Okay. So yeah. So again, I don't envision a world in which the defense attorney would not call Proctor. Like, we both are struggling with that, and which is why, if these reports are true, it's going to bring a lot of questions to our mind. Let me bring up this comment from Abacus Flinch. Thoughts on the balance of judgments about granting Commonwealth's motion to block mention of Birchmore and then denying defense's motion to mention a case that would impeach Hyde. Okay, so Solomon, you may not be aware of this, but what happened here is that Jessica Hyde, there's certain doctors, let's say, that we've seen in civil cases where there's specific opinions and findings by a judge that certain doctors were unreliable. And we use that to impeach the doctor, saying, hey, remember this opinion where this judge said that your theories were unreliable or your conclusions were unreliable? Well, there was a case where this witness, Jessica Hyde, was found by a judge to be unreliable in a certain specific area of her analysis. Okay, so Alessi, who was the defense attorney,
unreliable or untruthful?
No, unreliable. Unreliable in a certain area, but I think it had to do with location data or something. So he wanted to be able to impeach her with that opinion. Judge Cannoni said, no, we're not allowing that. We're not allowing you to do that. Now, they did just find the case, and it was like kind of, sprung on her last minute. But That's
she
what her
knew about
ruling
it
was.
beforehand.
That was her ruling.
Prosecutor may not have, but she knew about it.
Oh, she knew about it for sure.
Right,
But I think it was kind of like, she was kind of like under the gun, and Jessica Hyde was supposed to take the stand in another 10 minutes. And that's when this issue was brought up, and she kind of made a pretty quick ruling about it. On the other hand, there was the Sandra Birchmore case, which I'm not sure if you're familiar with that case, Solomon, but that's also a case that involves a lot of the same investigators and troopers that are involved in the Karen Reed case. And the Sandra Birchmore case is a case, and again, I don't know all the details, so if I'm saying something that's incorrectly, it's completely unintentional, and you can correct me if I'm wrong. But there's some allegations in that case that some of these troopers were looking for text messages and weren't able to find any text messages. And if they would have found these text messages, it would have implicated another fellow state trooper. Well, guess what? The FBI got involved, and they discovered something like, 3,000 text messages, 30,000 text messages, whatever it was, some crazy amount of text messages that existed between this state trooper and Sandra Birchmore, by the way, who ended up was murdered later. So the defense wanted to bring in this type of evidence to impeach some of these officers on the Karen Reed case, saying, hey, you think your investigation is so great? Look at the investigation that you did in Sandra Birchmore, where you missed these thousands of text messages and claimed, and now the jury's supposed to take your word for it. So they wanted to bring in that part. Now, Canoni did not allow them to do that. So this question basically is asking you, does it make sense, comparing these two rulings, like, how you did with Crosby and Dr. Russell? And I know they're not exactly the same, because it's not the same exact issue. They're two different issues. But this is what this person's asking. How do you square these two rulings with each other?
Okay, so let's just back up. The Crosby order and the order on the experts, there's really no way to reconcile those. They make no sense. All right, to require a 2-day Daubert hearing on one expert and then the other one nothing at all, you're good to go. There's really no way that I can think of that reconciles those, other than a judge who's incapable of seeing straight. That's all there is to it. As far as this Birchmore case, based on what you're telling me, and just in all candor, I've begun to watch the trial a little bit more closely. I'm not familiar with this until you started describing it, but based on what you're describing, I don't think that the judge is doing anything improper here. I think that the judge's ruling makes sense. This is going to be one of those things where it's very fact specific, and ultimately it comes down to whether you're just going down, a complete sideshow, and you're taking the jury on this unnecessary tangent just because you want to score a point with her credibility. If it's factually similar enough, like if it's the same exact type of evidence.
Tom, not to cut you off, but like one of the arguments that Hank Brennan made back was that you're creating a trial within a trial now.
Exactly, right. That's exactly it. If it's a situation where she's trying to say, in this case, A, B, and C, and in a different case she was trying to say X, Y, and Z, and the judge said, no, you're wrong, you blew it, you can't do it, then it wouldn't make sense to bring that into this trial and say, hey, right now you're trying to say A, B, and C. In this other case, the judge said you can't say X, Y, and Z. However, if in the other case you were trying to also say A, B, and C, and the judge said, no, you're not qualified to offer opinions about that, then it would be much more likely that it would be allowed in because it's on the same exact topic. Based on what you're describing, it sounds like these are distant enough that it should not be allowed in. Based on what you're describing, if I were the judge, I would not allow that cross-examination in either. And it's not that he was found to be untruthful. That's a different story. And that's where I thought you were going with this. Experts get struck all the time on specific topics. You may have an expert who's going to opine about 5 or 6 different things, and during a Daubert hearing, the judge may end up entering an order saying you're allowed to testify about numbers 1, 2, 4, and 6, and that's it. That doesn't mean that in all subsequent cases now you're allowed to say, hey, he's not an expert on these things, because it's very fact specific based on the evidence and based on the research that was done and the methodology and the testimony that was offered. Daubert's got a whole process with all kinds of factors to look at. So just because you're deemed unreliable for a specific topic in one case doesn't mean necessarily that you're unreliable for that topic in all future cases, and unreliable as an expert on all topics that are related. So I don't think the judge did anything wrong on this one.
Yeah, and again, I don't think it's apples to apples either. Like, like you were talking about, Crosby and Russell are much more is literally apples to apples, and
There's no way to reconcile that. I don't see
Exactly.
any way to reconcile that. That was a shameful order. That made no sense.
Collusion, not collision says the judge said the shoe gate happens all the time with evidence. Do you agree? Now, what happened here was, we had one officer, one state trooper, who came to the scene, and at 34 Fairview recovered a sneaker. Okay, so that was one sneaker. The other sneaker was at the hospital. Now, this is part of the Commonwealth's theory here that it was a pedestrian strike because he was knocked out of his shoes. Okay, now that's knocked out of your shoes when only your arm is getting hit by the car. Okay, but we'll deal with that a different time. But this is one of the
happen. If you're hit hard enough, it could happen.
Yeah, I mean, if a pedestrian strike, it could happen. You're hit out of your shoes. Just here, if the only part that's hit is your arm, it's going to be a little more difficult.
That arm was bit by a dog, not hit by a car. So.
Okay. Well, anyway, let's stay on. Again. We'll stay on topic.
Let's not try to convince people with NASA scientists that the Earth is flat.
Okay. So here we had the one trooper testified the day before that they recovered a shoe at the scene, 34 Fairview. The next day, Buchanan was testifying about the shoe that was recovered at the hospital. And then in front of the jury, he was asked, "Okay, where'd you recover that shoe from?" And he looked at the bag. He's like, "This is from 34 Fairview." So there's like this little like pause where everyone's like looking at each other. We need to take a break. And basically, there's some bags that were mixed up and whatever. So then he got back after the break and said, "Okay, this is the shoe that was actually recovered from the hospital." So I think this is what the question is referring to. Does that happen with evidence? Have you seen that happen with evidence? And is there really nothing much here, just mixing up the bags?
That happens all the time. That happens all the time. If you have enough exhibits and enough evidence bags and enough evidence tags, there will be mistakes. There just will be. Especially if there's multiple locations where evidence is collected. Yeah, I mean, I'll tell you this. If I'm the defense, there are other points I would make much more strongly than this.
Yeah, exactly. Don't chase every rabbit hole, right?
Like the fact that there's clearly dog bite marks on his arm and not vehicle strike.
Yeah. Collusion not collision says again, we want father counsel. Well, we got Father's Day coming up, so maybe we'll have father counsel for that. Let me see what else we have here. Stefan 7-pounder. Yuri visited young single women with Tully at their home and businesses because they insulted Lizzie Proctor. Disgusting behavior. So again, I don't know not much about that. So we're just going to leave it. I definitely didn't come out during trial. Let's see what we have here. Vanessa Rich, who is a supporter of the channel, has joined us, by the way, for the live streams. And all of you should join us for the live stream starting tomorrow at 10 o'clock in the morning. And join Vanessa Rich in the chat because it's a lot of fun. Shout out to Solomon for keeping it real. Love your channel, Brother Counsel. Always great discussion. Free Karen Reed, and happy Mother's Day to all. I can't disagree with that comment.
I feel like I should point out that there's two kinds of counsel. And council is COUNSEL and COUNCIL. A city council is COUNCIL. This show and a lawyer is COUNSELOR. People get this confused all the time. I happen to be a councilman in the city I live in and a counselor as a lawyer, and people misspell it to me all the time. But it's just something I'm noticing in a lot of the comments that
Solomon,
people are kind of using it interchangeably. So I just want to point that out.
Well, Solomon, if you try to start a show, Brother Counsel spelled CIL, I'm going to sue the heck out of you. Okay.
You know what? I kind of like it because it sounds better than Brother Counsel's Brother Counsel. So,
Discworld Edgewitch, how would you handle the suspect Sally put footage? Side note: your mom raised at least 2 real mentions, in my opinion.
Definitely agree with the second part there.
The Sally put footage. Okay, we haven't. I don't think we've seen the Sally put footage yet. I don't think it was brought out yet, but we're going to be talking about the inverted video, Solomon. You may know about that. The fact that there's 45 minutes missing. I think that really Alan Jackson addressed it quite well in the last trial. So pointing out how there's missing footage magically when it comes in, and you can never get a good picture of the back of the taillight. I think they're doing a great job. Right. Here's another question.
Yeah, that's and I think that's a very, very strong point. If there would just be one thing, about this taillight that is a question mark, that's okay. You can explain that away. When every single thing that touches the taillight is nothing but question marks, eventually you just got to kind of say something funny is going on here. Okay, and that's something we'll get to with Buchanan's testimony about the fact that there's no pictures, the fact that days later there's still massive pieces being found after he already searched a couple of times. I mean, there's all kinds of
Solomon, why don't you give us give me some of your thoughts, because now that you brought it up, we'll get to this comment in a minute. This issue that Buchanan spoke about, that he was at the scene on the 10th when he testified, there was very little snow. And some people have told me that, and again, I didn't do like a deep dive into this, but that the weather was beautiful. There was no snow anywhere. Well, let's just even assume that there's a little bit of snow. And then you find those two big pieces of taillight the day after he was out there. Buchanan was there the 10th. Proctor went on the 11th and found these 6-inch wide taillight, and then tall, also probably another like 4 or 5 inches tall. They're big pieces. And he was there searching the day before. They said, and again, remember this, because this is an important part. He kept saying the reason why he didn't take pictures is because they're all found within the general vicinity of the same area. They're all found within the same general vicinity, flagpole, mailbox. So where you're looking. He looked there the 3rd, the 4th, the 10th, and then the next day, Proctor was able to find this big piece, and then a few days later, the 18th, he was able to find even bigger pieces also. So what do you think about that? And also the fact that he didn't take any pictures of the taillights on those days.
Okay, so there's two things to unpack here. The first thing is, where did those pieces come from? Were they left there from the scene when supposedly, according to the prosecutor, Karen hit John and apparently shattered her taillight and left pieces all over the place that weren't found?
46.
What's that? 46, right? Or is there some other explanation? So there's the principle of Occam's razor, which I'm assuming that a lot of your viewers are familiar with, but
everyone is familiar with it because we've been hearing so much about Occam's razor about this case from both sides. Both sides
okay.
have been saying Occam's razor.
Occam's razor is something that we talk about in litigation all the time, and it's basically that the simplest explanation is usually the correct one, and the one that makes the most sense. So just looking at this without hearing any explanations and without hearing any long-winded, lectures, he's there multiple times looking for pieces. There's no documented evidence of pieces being there. It's not in any reports. There's no pictures.
Well, it's in the report. The pieces in the report, the pictures. Yeah.
Right. But then suddenly days later, there's another massive piece found that somehow was missed and was not pictured and was not documented. So what's the explanation for that? Was it there when Buchanan was there or not? Occam's razor would say, no, it was not there. It was put there later. Okay, that's number one. Number two, ultimately there's a big question here of why weren't these pictures taken? And I forgot what Buchanan's testimony was because the guy was so evasive and refused to answer questions.
I'll tell you. His answer was because it was all found within the same general vicinity. So why keep taking pictures of additional evidence? We already have pictures of the other evidence, and it's all within the same general vicinity anyway.
Oh, good. So there are pictures of the broken tail light there. Of all
there are pictures of other pieces. There's 46 pieces that were recovered.
Of all pieces.
No, not all pieces.
If there's a shooting, let's say, and there's 30 shell casings, and then somebody takes a picture of 6 of them and says, well, I mean, they were all in the same place, so why take pictures of all 30? That is lunacy, and it makes no sense. And it makes you wonder, why would somebody make such a lunatic, such a ridiculous claim? Why would somebody make a claim which is lunacy on its face? And the bottom line here is, you have to ask yourself, does the lack of competence explain what happened here, or was there intent going on? Let me give you an example of what I mean. Let's say you've got a doctor who's about to do a surgery, okay? And the doctor is about to amputate a leg, all right? And the doctor amputates the wrong leg. It could be explained. It could be a mistake. It could, or if let's say it's supposed to be from the ankle and they go up to the knee, it could be explained. It's a big mistake, but it could be explained as a mistake. If a doctor's supposed to do a surgery and he's supposed to amputate a leg, and instead he cuts off both arms and does a heart transplant, then you got to ask yourself, was this a mistake? Is there any plausible way of saying this was a mistake, or did this doctor do this intentionally? Because incompetence does not explain how bad of a job was done. The cops here are stuck in a position where their defense of their own actions is, we are so utterly incompetent that we did something this colossally stupid. When that's the position you have to take, you got problems. Okay? Because the alternative is, we intentionally didn't take enough pictures. We intentionally didn't document things correctly. We intentionally did all these other things that make no sense. So they're stuck with only two possibilities. Possibility number one is, we are so colossally incompetent and stupid that this is what we did. And the other one is, we intentionally did this wrong. And that's ultimately the only two choices that the jury has.
Yeah. So here that would be a good segue into the next question. Collusion, not collision asks, motion to reconsider Easter. So you'll remember we had this discussion earlier in one of our other streams that we did together, and that was the question of Michael Easter, who is, from what I remember, was the expert in police investigations, who Alan Jackson wanted to bring as an expert, and Judge Cannoni did not allow to talk about investigations. And here would be a perfect example of the jury understanding from an expert like Michael Easter that no. Just because they're all within the general vicinity doesn't mean you don't take pictures of it. Of course you take pictures the same way, like you just said, you take pictures of shell casings. Now here's the issue. She already denied the motion. So the question is, should they reconsider it? Should they do a motion for reconsideration? They could, but like, you know that 90% of those are just, denied anyway. So
probably more than 90%.
But you agree right away that, you've agreed with us that, of course, to have a detective expert in investigations be able to testify would be appropriate. So I think you've said your point about that. Here's another comment from Steven 7-pounder. Imagine, if you would, a dead guy showing up on your lawn. Would you expect a knock on your door? Not at 34 Fairview. Shh, a cop lives there.
Yeah, we've talked about this.
We've spoken about
the fact that there was no investigation done of the people in the home, no search warrants, no real investigation, and then the cops have the audacity to get up and say that there was no bias and that all evidence pointed in one direction. Come on. No, I don't think anybody's going to buy that. I really don't.
Yeah. Like I've said, I maintained this from the beginning. I think the fact that house was not searched, is also.
I will say this: unless the prosecutor has a major ace up their sleeve, I don't see how they can possibly win this case at this point.
Here's a question from Kristen from Manhattan. Which witnesses would you call as the defense, i.e. Higgins, Albert, that weren't called during the prosecution's case in chief? What challenges will this present to the defense? Bro, counsel, SR saw a post on your PA case.
Oh.
Pennsylvania case? Okay, so the witnesses that we'd call on, I'm going to tell you from me, if the Commonwealth really is not going to call Proctor, which I think is, again, a tremendous mistake, unless there's some backdoor stuff going on that we don't know about. But if they don't call, I would call everybody. Call Higgins, call Albert, call Proctor, call all those people. Of course, explain your butt dials to each other at 2:00 in the morning, and your butt answers. Do that.
If you're the prosecutor and you don't call these witnesses, you're letting the defense tell the story. Every witness tells a story. And if, let's say, you were going to call, let's just say Brian Higgins, okay? If I'm the defense attorney and Brian Higgins is not called by the prosecutor, I'd get him up on the witness stand and ask him maybe 20 questions, just hammering home the most important points. Where's your phone? Where's Chloe? Just some very basic leading questions, yes or no, prove to the jury what you're trying to prove, and then say, done, I'm done. I actually had a case where it was a civil case. I was suing somebody for a sexual assault of my client. And what I did was, as soon as the trial started, they all thought I was going to call my client first. I didn't. I called the defendant. And I got him up on the witness stand, and I asked him, he was on the stand for maybe 5 minutes. I asked him a few very pointed yes or no questions, And then I said nothing else. I sat down. And the defense attorney was shocked. She had no clue what to do. And then she just kind of said, well, I'll reserve the right to call him in my case in chief. Fine, go ahead. Do whatever you want at this point. But the thing is, for a witness like all these witnesses we're talking about, if you let the defense attorney tell the story, it's going to be a much different story than if Hank Brennan calls them. That's why I think all these bad witnesses, Hank Brennan's going to have to call.
Yeah.
Because if he lets
100%.
the defense call them, it's the testimony is all going to come out differently.
Exactly. Here's another comment here. True truth for liberty. The expert was found unreliable in the other case. It was a Maryland case. We're talking about Jessica Hyde again. Because it was a point where the source code was unavailable. Same now. And this is the issue. The Apple source code. Okay, this is where it comes down to like a little bit understanding how this works. Apple source code, nobody knows. It's like the Coca-Cola ingredient.
Right.
You know, nobody knows the Apple source code, so they create all these other programs to be able to make sense of the information in the phone. So really, nobody is ever able to get to the Apple source code. And this is really what the issue was. And the judge in that case found that for this specific area that Jessica Hyde was testifying in this Maryland case, because she didn't know the Apple source code, so therefore her opinions were unreliable. And in this case also, you know, she doesn't know the Apple source code. But, you know, again, it's a hard opinion to really base on because really nobody ever knows the Apple source code. So where exactly do you draw the line? It's not so clear.
Also, the judge doesn't have to listen to the Maryland judge. She could rule differently.
Right. But the question is whether... Yeah, but the question was whether they can use that as impeachment. You know, whether not to ask the judge to find that she's unreliable, but just to be able to use it as impeachment for Jessica Hyde.
I don't think so. I still think that the judge got this right. I'm sure the defense is going to have their own experts that are going to counter what Jessica Hyde said. Jessica Hyde was the cell phone expert with the head on her head.
Yeah,
I did not think she was a very good witness. I really didn't. I think that she came across as a know-it-all. She came across as arrogant. She didn't let anybody finish a question. Every single sentence that was said, whether from the prosecution, the defense, or the judge, it felt like every single one, she would jump in because not only did she know what you were going to say, but she wanted you to know that she knew what you were going to say, and she wanted you to know that she already knows the answer to what you're going to say. And she ended it with some comment about like, absolutely. Thank you so much for your questions. It's condescension. It's passive aggressiveness. That stuff doesn't work. It really doesn't work on juries. I don't think she presented very well.
You thought that she was trying to show that she's the smartest person in the room?
Yeah, she was trying to show that. That's certainly how it seemed.
Okay, Darth Mac saw clear glass
to a jury.
Darth Mac says saw clear glass and snow, but not red plastic. So we're talking about what pieces of plastic Buchanan found. Wasn't able to see those gigantic red pieces of taillight, but he was able to see some.
Let's put this to rest. I know a lot of people are saying, oh, there was snow, and as the snow melted, they found more and more pieces. No, time out. When there's a murder investigation and you know there's pieces there, you keep looking until there's none left. Okay? That's all there is to it. There's nobody in the world who's going to explain this away by saying, oh, well, there was so much snow that we just decided to leave all these pieces there and not photograph all of them. It makes no sense at all.
Yeah. I mean, part of that, what that comment was saying is that Buchanan was able to find some pieces of clear glass, but that big red gigantic piece he wasn't able to find, and Proctor found the next day. Some guy with cancer. I'm sorry. I hope you have a harder recovery, a full recovery. Bev's order on the MTD is flat eartherism. I think that means on the motion to dismiss is flat, meaning not even having a. Remember that motion to dismiss we spoke about a few videos ago, where she didn't even order an evidentiary hearing, where there's some Brady violation.
I know that there were a few issues that were raised. Which issue are we talking about?
Well, they're just he's saying that the order on the motion to dismiss, where it was based on the fact that these videos were not turned over until much later, and then and Proctor hid them in his file for like 2 years. You know, so there was no hearing on that, and that was. I
wouldn't call that flat earthism. The only thing in this case so far that I've considered flat earthism is trying to convince a jury that that the wounds on the arm were caused by a car, not by a dog.
Yeah. Again, Stephen Seven Ponder. What is the name of the? What is the name of the CERT team member who found the evidence? That was Kevin O'Hara, I believe, who found some of the. Again, what we have in this case, Solomon, is that the CERT team was out there before any of these other troopers were there, and they found 6 or 7 pieces of tail light in the street. Okay, so the street is about 10 feet away, at least, from where John O'Keefe's body was found. And there's about 6-7 pieces of taillight that were all found within about a foot of each other. And then there's another 40 pieces strewn about the lawn about 10 feet away. Try to make sense of all that.
It doesn't make sense.
Well,
Occam's razor. Make sense of it.
Well, they're actually.
Did that happen naturally or did it happen unnaturally? Did somebody put it there or did it happen by accident? Occam's razor. Well, you make sense of it.
Yeah, exactly. Well, their action reconstructionist hasn't testified yet, Solomon. So we'll see how he's going to try to try to make sense of all that. Jody Arrington sends $10. Thank you, brothers. I appreciate your insights. No problem. I want to get to another thing before I want to get to all these messages, obviously, also, but I also want to get Solomon's opinion about something in a minute. Every time I think there's no way a jury can convict in this case, I remember Casey Anthony, and I don't feel as sure anymore.
What?
Did you see that?
No, put it back up.
You know the case of Casey Anthony, Solomon?
Yeah, I remember that one. Yeah.
Every time I think there's no way a jury can convict in this case, I remember Casey Anthony, and I don't feel as sure anymore. So I'm not entirely familiar with the Casey Anthony case either. Here's
one second. Hang on 1 second. Put that up again.
Casey Anthony?
Yeah, the fact that she was found not guilty is what?
Here.
Is going to show, okay. Every time I think there's no way. Oh, okay. So what this person is saying is that the same way a jury was able to find Casey Anthony not guilty, maybe a jury could potentially be dumb enough to find this person guilty. Well, you're not going to like this, and we can talk about Casey Anthony another time. I don't think the jury got that case wrong.
Woo.
Juries have to make rulings based on evidence, and I followed that trial very closely at the time. I'm a bit of a trial nut, not as much as you in this case, but I've watched a lot of trials over the years, and that was one of them.
Wow. Okay, look at that hot take from Salmon. Okay, we'll have to talk about Casey Anthony, I guess, a different time. Barbara Brady, if there were taillight pieces there, the people doing CPR would have kneeled on them. And the time that just to be fair, the time that the CPR, the paramedics were there, they were literally in the middle of a tremendous storm. There was 24 inches of snow at that point. So I mean, that's not as
it was chaotic. There's a lot going on. She's making comments about did I hit him or I hit him, and by the way, just one last thing. I mean, I don't know why I'm kind of going off on a tangent now, but remember that scene in which movie was it with Joe Pesci? My Cousin Vinny.
My Cousin Vinny.
Yeah, I shot the clerk.
Yeah. No, people could talk.
So I shot the clerk is like I hit him.
Right.
It could easily be that she may have said I hit him, but it wasn't matter of fact, and she probably didn't say I hit him because that's not what anybody remembered until years later.
Well, yeah, nobody put it in any reports, that's for sure. And in fact, remember Jennifer McCabe's grand jury testimony that also kind of got left out.
Right.
Steven's 7-pounder, Bukaki could not name the CERT member because he had no idea who found the taillight.
Interesting. Okay.
Okay, Solomon, I want to get your take on the text messages. Okay, this trial, this time around, and I'm not gonna. Everybody here knows my opinion about these text messages. Let me just tell you what happened in the last trial. The first trial in this case, Brian Higgins was on the stand, and he was the one who read the text message exchange between Karen Reed and himself. And there's obviously some flirtatious text going on, and Karen Reed must have not been in the greatest place at that point, and maybe she was thinking about hooking up with him. Let's just call a spade a spade. Mm-hmm. But then, as the relationship continued, that's the question of where her interest level went. And in last trial, I thought from the way that the prosecution brought out, they were the ones to bring out these text messages, and they were able to cherry pick. So they were jumping around different dates, and they had it set up in a way that it looked a lot more to me that Karen Reed was legitimately, continually interested in Brian Higgins the same way he was. In this trial, they read the entire text message exchange, and this was brought out by the defense. And I don't think Hank Brennan was ready for this. I think this caught Hank Brennan off guard. It definitely caught Judge Canoni off guard because she at one point turned to Buchanan and said, or turned to Jackson and said, is he going to read all the text messages now? He's like, you better believe it. And then they approached the sidebar, and he said, because since this is something that he took into consideration, part of his investigation, it should be able to come in. Hank Brennan, I think, was caught off guard. And by reading the entire text messages, I felt a little bit different impression about where Karen Reed was with this hookup or whatever you want to call it, this fling leading up to the murder. What do you think about it?
Yeah. Definitely. I mean, what specifically are you asking me? Break it down a little bit more.
I want to know, number one, what do you think about the defense bringing out these text messages, number one, instead of waiting for the prosecution to bring it out? Number two, I want to know, you saw a lot of those text messages, right? And I wanted to know, what is your take on what was going on? If the prosecution is going to try to use that as some sort of motive for Karen Reed wanting to knock off John O'Keefe so that she can go hook up with Brian Higgins, do you think that type of argument is going to work? What did you feel about this relationship between Karen Reed and Brian Higgins? Did it kind of get stale and sour? Where do you think each party was? Do you think Brian Higgins was not as interested and kind of like just feeling her out, and Karen Reed was like ultra interested? Like, what do you think about where each person was by the time days leading up to this incident?
Okay, so first things first, I think this was an absolutely brilliant move by Alan Jackson. I think that by bringing out the messages first and having all of them read completely takes the wind out of the sails of what the prosecution was going to do and what they did the first time around by reading some of them and telling a certain story. Okay. I think what this does, I don't think this helps the case for the defense that much. I really don't. But I think what it does is it completely disarms and deflates whatever the prosecution was going to try to do with portions of these messages. And that's why this is such a great chess game, watching Hank Brennan and Alan Jackson go at it. And this was definitely a fool's mate, so to speak, that Alan Jackson pulled off. He knew what Hank Brennan was going to do through a different witness and beat him to the punch. And that way, whatever Hank Brennan was going to try to do by showing certain messages and telling a certain story, that was completely taken away. It was completely deflated. He popped the balloon. And I thought it was very well done. Now, that said, what does it show? It shows that at first they were flirtatious with each other. Maybe they had a genuine interest in each other. And then it went away for Karen, but did not go away for Brian, that he was continuing to pursue her and she didn't want to be pursued at that point. Does that help anybody? Does that hurt anybody? I don't know. I don't think it does that much. What it does do is it completely disarms the prosecutor from using these the way he wanted to use them, which is why I think it was such a brilliant move. I
completely agree with you. I think it was brilliant. I don't think Hank Brennan was ready for it. And yeah, I think they must have planned this, and it was just, I think it was brilliant. Also, I want to make another point. And do you think that this maybe shows Brian Higgins as a motive for him to knock off John O'Keefe? Because it seemed like he was still much more interested in this relationship. And at some point, there's an issue there because she's got this boyfriend, and maybe that's what's stopping her from pursuing this. And he kind of let his feelings out of the bag by saying, yeah, I thought you were hot from day one, from the jump. And, I thought you had this awesome personality, and like, it's kind of like letting out his feelings. And then she's kind of like, all right, ghosting him a little bit. And then
I don't think this establishes a motive for murder for anybody, which is why I think it was such a strong move by the defense.
Yeah.
I don't think it establishes a motive for Karen or for Brian to want to kill him. I just don't. Mm-hmm. But the way the prosecution was planning on using these messages, you no longer can. And that's why this was such a strong move and such a good move.
Aunt Nancy says, why isn't John's socks in evidence? He always took his shoes off before entering his home. This is a question that I really don't know the answer to. I really wonder where his socks were. I know that I've gotten emails about this. I've gotten questions about this. And I think that's a legitimate question. Where are his socks? Where are his socks?
I don't know enough about this.
I know. Yeah, I know. I'm just talking out loud. I really don't know what the story is with the socks. I think that's a good point. And I think it should be explored. I don't have a good answer to that. I really wonder. But I think it's a good point. I think it's a good catch. And I know that I've gotten other emails and comments about it. And I wonder, has Turtle Boy said anything about the socks? Because he knows a lot. He knows a lot details about this case that a lot of people don't know. Here's a account from Two Truth for Liberty. No Apple source code. Problem was not that. but the testimony conclusion claimed as scientifically reliable rather than based on my research. Oh, maybe that was the issue.
Okay. I don't know.
Yeah, I know. English Kate, really appreciate this no BS review of a very bad case. We need good attorneys to call these tyrants out. Oh, Solomon, there you go.
Okay. I'm calling it the way I
Question.
see it.
Discworld Edgewitch, do you think the text would have all been read in if Buchanan hadn't been so evasive about whether they were flirtatious? So this is, well, he was asked about those text messages, whether they're flirtatious, and that's kind of how they got to these questions. So he's able to establish that, wait, you read all these text messages, and now let's go back to the question, were they flirtatious or not? And then he started being evasive about, well, I wouldn't call them in general flirtatious. Maybe there's a text or two when he says you're hot, something like that. But do you think the text would have been read if Buchanan hadn't been so evasive? I think that they could have gotten them in anyway through Buchanan because it's something that he took into consideration as part of his investigation. What do you think, Solomon?
Yeah, I'm with you on this. I think that he could have gotten it in as soon as there was testimony that these messages were reviewed and considered. And I think Alan Jackson was planning all along on asking that question, getting that answer, and having all the messages read right then. I think that was his plan. It's a chess game. Ultimately, when you're playing chess, you can only plan so far in advance because they may make a move that will completely change your strategy. But sometimes you kind of know what they're going to do. And I think this is a situation where Alan Jackson was relying very strongly on the testimony being, yes, I relied and reviewed these on these texts. And then, boom, now they can all come in, and he can completely take the wind out of the sails of the prosecutor for using the messages the way that they wanted to.
Yeah, and got to give Judge Cannoni credit because she allowed him to do it.
There would be no basis not to, but yes, let's give credit where credit's due. She did not run interference with the prosecutor on this issue.
Jiro OO, who's got a picture of the straw man from The Wizard of Oz. How credible are the statements from before that there were microscopic tail light fragments in John's shirt? So there is going to be some testimony. I know there was testimony in the first trial, so I'm sure there's going to be testimony in the second trial that there was microscopic pieces of tail light in John's shirt. So what do you make of that? Whether he was actually hit by her car, or was it just mixed up with some of the other evidence, or lying there, or how did it end up?
Well,
there?
this is the first that I'm seeing this. I'm going to be very interested in seeing what the actual evidence and testimony is on this topic, because it could certainly change my perspective on a couple of things. However, the questions that I'm going to have right off the bat are chain of custody of not only the taillight, but also of the shirt. Chain of custody is incredibly important, because I'll tell you right now, if Proctor at any point in time had possession and custody and control of both the shirt and the taillight, I'd say it doesn't matter what it shows; it's completely unreliable. That's all there is to it. It completely depends on the chain of custody of both. But that's and then obviously after that, I'm very interested in hearing and seeing what the evidence is on this topic.
Well, I'll tell you about the chain of custody. First of all, that's a dirty word in this case, chain of custody, because there's some problems with chain of custody in this case, to say the very least. But what happened with that shirt is that his clothing were cut off of him in the ambulance. Then they were wrapped up and put in a ball in the hospital, and they're sitting in a corner in the hospital. Then later they were bagged and put in an evidence room, laid out to dry on butcher paper.
Wait, stop. Wait. When you say bagged at the hospital, who came into the hospital and picked it up?
The Buchanan and probably Proctor.
Okay. Then as far as I'm concerned, anything that was found on it afterwards is not reliable, but I digress. When you say bagged, typically evidence gets bagged and tagged. It gets sealed and then put a tag on it that shows with a signature and a date showing that it's sealed in this bag at this time on this date, and this is when we took custody of it. But now you're saying that it was brought back after it was bagged and laid out on butcher paper?
Yeah.
So it was laid out on butcher paper and untagged and laid out on butcher paper in a police station?
In the Canton Police Department.
Where Buchanan and Proctor had access to it?
I'm not sure. Well, they must have had some level of access to it because they were able to go in there and lay it out. And then what happens is, then listen what happens. And then it sits in that evidence room for about 3 weeks before it gets transferred to an evidence lab.
Mm-hmm.
So that was
completely unreliable. As far as I'm concerned, completely unreliable. I don't care what it shows. At that point, they already came up with this. At that point, I think the defense can make a very strong argument that Buchanan and Proctor already had access to both the tail light and the shirt, and were able to do whatever they wanted with these microscopic pieces, and then sent it off to a lab and said, hey, look for microscopic pieces. So as far as I'm concerned, based on this chain of custody, the evidence is completely unreliable.
Well, there you go. Okay, I can't even say this name yet. But socks are on the autopsy pics, and that's true. The autopsy picture does have him in socks, but not in evidence. Blood or dog hair on them. So, yeah, I don't know what happened with the socks. They were definitely in the pictures of his autopsy. So I don't know what to do about the socks. Here's another gray space. Socks were on at autopsy, but not in evidence. How does that happen, Solomon?
Occam's razor. You tell me. What's the easiest explanation for that? Incompetence or intent?
Paul Croak. They made the same mistake on shoes on separate days. Connor and Bukaki, different bags. Connor Keefe was the other trooper. Found it. Okay, let me see if we can get down the questions before we let Solomon go. Well, we're already getting late here. Michelle says, introducing these texts, the videos, and then later link it to Higgins' started behavior, getting rid of phone, but I was going to PD, will go far. So Michelle says this is also just kind of agreeing with us that these text messages getting in now, and then they're going to be hearing later about how Higgins was on the phone at 1:30 in the morning at the Canton Police Department. Well, we shouldn't say that he was making a phone call. It was just near his face. And also that he got rid of his phone. And then there was butt dials to Brian Albert. He destroyed his SIM card on his phone in the military base. So putting all these pieces together, the jury should get an idea about what happened.
I'll tell you right now, one of the things I enjoy watching is UFC fights. And I think when Alan Jackson dismantles Brian Higgins on the witness stand, it's going to be reminiscent of a UFC fight. A very one-sided UFC fight. I don't see how Brian Higgins is going to testify with any sort of credibility after Jackson gets done with him. And by the way, I don't know what kind of sequestration order is in place as far as witnesses watching the trial.
Oh, there is.
I'm sure there is, but I mean, I don't know how enforceable it is. And of course, if a witness gets up and says, yeah, I haven't been watching the trial. If there are witnesses, I'm not going to say they are because I don't know if they are, but if there are witnesses who are going to testify, who are going to be cross-examined by Alan Jackson, who are watching the trial so far, they must be absolutely terrified. Because I got to tell you right now, we know the names, right? The people who are Proctor, Higgins, Albert, when they testify, can you imagine if they're watching this trial, anticipating what Jackson is going to do to them?
It's funny because some people have even been saying that, like, oh, Jackson's not as good as he was during the first trial. And I don't agree at all. I think he's doing
I didn't see the first trial, but I can tell you right now, Alan Jackson is putting on a clinic on how to try a case.
Yeah.
He is dismantling the prosecution's case.
Yeah.
Dismantling it. It's unreal. There's nothing left of Buchanan. There was nothing left of Jennifer.
Yeah,
he knows when to go for the jugular and when to just throw a few jabs, like that paramedic who testified, Katie
Nuttall. Oh, Timothy Nuttall or Kate McLaughlin?
Kate McLaughlin. He didn't punch too hard. He made a few points. He certainly didn't do to her what he did to Buchanan. You got to know when to stop throwing punches, and I got to tell you,
funny because I remember you sent me a text message, like I think it was even the first day of his cross-examination, and you sent me a text message and you're like, he's finished, he's already destroyed, and I'm like, he's not even close to finished yet, like, and then Buchanan, yeah, and then like the cross-examination it's continuing on Monday.
He shredded him. There's nothing left of this guy. There's nothing left. I don't see how any juror could look at him and think that he's being truthful. And by the way, just because we just talked about her for a second, just a point about about the paramedic. It's very interesting how this works with memories can be implanted into people in a much simpler way than you may think. And there's studies that have been done on this, and it's very interesting. And as somebody who tries cases regularly and hears witness testimony, there are times I'll be thinking to myself, this person is lying. But why would this person lie? They're saying this so truthfully. They really mean this. They really think this. And I think this explains some of the testimony in this case. Like, there are some witnesses who I think have been taken advantage of and have had memories implanted into them. And let me explain to you what I mean by that. Nobody's doing brain surgery or doing, any sort of, hypnosis. But there's a particular study, and I remember seeing this. I remember reading this, and I remember seeing a video about this, where what they did was they had a group of people, and they were the study subjects. And then there were a few people who were part of the actual planning of the study. And what they did was they had a whole group of people outside in a public place. And then while somebody was making a presentation of some sort, somebody runs up and grabs somebody and does something and then runs away. And then what they do is they talk to each person. They talk to this group of people and ask them, what did you see happen? And so whatever it is that happened, somebody runs up and grabs a purse and then runs off. Okay. Then they start asking questions of the people who are there. They bring them into a room and they say, okay, you all were watching this presentation. They start asking questions. Okay, the presenter, man or woman, everybody got it right. Black or white, everybody got it right. Glasses or no glasses, everybody got it right. Okay, the person who ran up and grabbed something, what do you all remember about that? And before anybody can answer, somebody sitting in the back of the group says, well, I remember that somebody wearing a red coat ran up to somebody wearing a white jacket and stole her camera and then ran off to the side. And then what happened was everybody remembered that happening. And ultimately, they got to the point where every single person there was willing to swear on a stack of Bibles that the person was wearing, let's say, a white jacket. And the person was not, in fact, wearing a white jacket. And they asked them, you would testify right now if this were a case that the person was wearing a white jacket? Absolutely, 100% yes, white jacket. And then they played the video of the whole thing happening, and there's nobody wearing a white jacket. And then they say, how did this happen? So then they explain what happened. The first person who spoke up in the back was a plant and was part of the study and basically implanted that memory into everybody. And I think that on a different level, that may be what's happening here with some of the witnesses. That there are some of the witnesses who are intending to tell the truth, who know certain things that happened, but based on their interactions and their conversations with people whom they trust, they now are truthfully remembering certain things that they really don't remember happening, but they think they do remember happening.
All right. Well, that's an interesting theory right there. Very interesting study, by the way. Pokey SD says shirt not tested, fragments handed over by Proctor. Okay, so the fragments were handed over by Proctor. The shirt was not tested. Those fragments that were found in the T-shirt of John O'Keefe. We've got Anna Jasky. Thoughts on how/why they presented Officer John O'Keefe's shirt and sweatshirt in plexiglass. Love both of you together. So this time, Solomon, they presented. Last time they took the shirt and the sweatshirt out of an evidence bag, and they showed it to the jury. This time they had them in plexiglass, and they showed the plexiglass to the jurors. Any ideas why they would do that? I mean, otherwise, just for preservation purposes. What do you think that there's?
It's not for preservation. It's for demonstration. It looks better that way. It's kind of like when cops testify. Sometimes they show up wearing suit and ties, and sometimes they show up wearing their badges and their uniforms. I think it's more presentation than anything else. I don't think it has anything to do with.
Okay, Stu basically asked the similar question. They think some people are probably thinking that they're not going to see the evidence as well. And Montana Little says the clothes were laid on butcher paper on the floor of the MSP office at the courthouse. So that's how they have to dry the clothing after all. So that's what they did in order to dry them. Right. Vincent Lanzino, it was accident. Higgins intended to rough him up, not kill. Who would murder someone with all people inside? Two boys fighting over a girl. Video of waterfall. Higgins was jacked up, calling to John O'Keefe. So Salman,
that's kind of what I think happened here too. By the way, I don't. That's what I think happened here. I don't think that this was intentionally murder. I think that this was roughing up. Accidentally murdered him or accidentally killed him, and then went into cover-up mode. And that's why there are those very, very strong text messages, those group messages, basically trying to coerce Karen Reed into a plea. If she pleads, none of this comes out. None of this comes out. None of the statements are taken. None of the statements that were taken a year and 2 years and hundreds of days later, none of that gets documented because she pleads. And I'm sure she could have gotten some ridiculous plea bargain. She probably could have gotten some sort of plea bargain where she would have gotten probation. I'm guessing. Because they wanted this case to go away in the worst way.
Yeah, I mean, I know that you thought that those group text messages was very damning.
Very, very, very. I mean, you talk about reasonable doubt. The defense doesn't have to prove innocence, but I got to tell you, they're getting really close to proving innocence. And the prosecutor's still putting on the case.
Yeah. Gray space, every time you talk about a memory, it changes.
That's true, by the way. That's actually true. I've seen the study on that every single time you remember something, your brain is creating a new image of it. That's my understanding of it. I'm certainly no psychiatrist, but yeah, that's why every single time you recall a memory, it does sometimes. You're creating a new memory. It's a memory of the memory.
We keep hearing from insiders that the jurors are smirking and laughing out loud. Are the jurors in jeopardy of being replaced because of their outward reaction, Solomon?
No, it is virtually impossible to remove jurors. You have to prove so much to prove that a juror is not worthy of sitting on a jury. I've had it happen once. It was extremely improper of the judge to do, and the case ended up getting reversed based on what the judge did. The jurors are untouchables. That's why the jurors are handled with kid gloves. They're treated like gods. That's the way everybody treats jurors. They have to be treated that way. Our entire system depends on it.
Yeah.
So if a juror is laughing or smirking because of testimony, well, then I got to tell you. And by the way, I do this with my cases. I'm often, and you and I were both pitchers when we were kids, so we know how to look out of the peripheral vision. If we're sitting there looking down at our notes or at our laptop, we're looking out of the corner of our eye at the juror. We want to see how they're being. Are they receiving what's being said? What's their body language? Are they laughing? Are they smirking? And it tells you a lot. If there's a witness that the jury is believing and it's a bad witness, you got to hit that witness a lot harder than if there's if somebody says something and the jurors are kind of looking out of the corner of their eyes at each other like, did you hear that? You didn't really hear that, did you? Did you hear what that witness just said? Then you don't have to attack them too hard. In fact, you could just get up and say something to the effect of, did you just say this, that, and the other thing? Yeah, I did. Okay, thank you. And then that's it. And now you got the jury laughing even harder. No, the jury's allowed to show reaction, show.
Right, I agree. And then, but I think everyone's very sensitive about this because there was a juror that was dismissed in the first trial. So I know we spoke about that a little bit. Well, yeah, we spoke about it, but the juror was called in. I
don't remember the details.
Yeah, okay, whatever. We don't have to open that up again. John Beatabot, is Hank Brennan at risk professionally for putting up witnesses who've lied to the FBI in this case, or is it a free pass?
Okay, so go ahead.
No, go ahead, Solomon.
Okay, a lawyer is not allowed to put up a witness if they know they're going to lie. I don't think Hank Brennan is doing that. I've said all along that I think Hank Brennan really believes that she's guilty. It's, I think, rare that lawyers put witnesses up that they know are going to lie. It happens. We know it happens. But it's completely unethical. It's illegal. And in fact, it could be considered criminal. I know a lawyer here in Michigan who was going to have a witness commit perjury during a murder trial. And on the day of the trial, he showed up and got arrested for solicitation to commit perjury. It's one of the wildest things that has ever happened in a Wayne County courthouse. And a lot of wild things happened in Wayne County courthouses here in Detroit. But that's something that happened. The guy showed up the day of trial and got arrested, taken into custody and charged, got convicted. He's in prison right now, as far as I recall. But no, you're not allowed to put a witness up. But is Hank Brennan doing that? I don't.
No, I mean so. they're talking about the fact that Carrie Roberts was impeached by, that saying that she heard when the question was, did you hear Jennifer McCabe ask? I'm sorry, Karen Reed asked Jennifer McCabe to make the Google search, and she said yes, and she was impeached on that fact. So is Hank Brennan not allowed to put up Carrie Roberts when he knows in the past during that grand jury testimony she testified in that way?
No, the only thing you're not allowed to do as a lawyer is you're not allowed to put them up now if you think they're going to lie now.
Exactly.
If you learn subsequently that they committed perjury, you have to tell the judge, which is wild. But
okay, and then
it almost never happens. But that's what's required. So if he learns that absolutely somebody lied, I would expect him to come forward and tell the judge.
Right. Lucid Visionary Girl 88 says not 24 inches when they found him was 4 inches of snow. Yes, I think by 6 a.m. maybe it was 4 inches of snow. There's a blizzard going on. There's chaos. There's 4 inches of snow. So to say that the paramedics, should have realized that there's taillight around, it's not the greatest.
But there's no pictures. There's no pictures of all the pieces, and they keep finding them days later and weeks later. It doesn't make sense. It's inconceivable. Occam's razor, baby.
Meatball Morrissey, Sketchy Stain, they yeeted 3 jurors last trial for showing disgust. Yeah, so that was the issue that came up in last trial about there's a juror
the trial.
Well, this
during
is right
during the jury selection.
No. This was right. I think they're talking about the one juror that was dismissed. Was that Victoria George, who's now joined the defense team? Or was that a different juror? It may have been a different juror. There was some sort of juror. There was a juror that maybe was having conversations. It was reported to the court officer. It was first reported to Lieutenant Fanning, and then it was.
But that's why she wasn't dismissed for laughing and smirking.
Right. Yeah. Right.
There's a whole separate basis for that.
Right. Slinky
jurors
sends $2.
Jurors don't get struck for smirking and laughing.
Right. Thanks for that. John Beat. Wow. So Hank has to claim ignorance of FBI.
No, not ignorance of FBI. Hank has to be able to say, and I think he could truthfully say this, that when he's putting witnesses up right now to testify, he does not know that they're going to lie. That's all he has to be able to believe, and I think he believes that. Exactly. I don't think he's putting up perjured witnesses.
Exactly. Okay, well, Solomon, we've kept you here for a nice long time on this Sunday, Mother's Day. We have some jobs to do. I'm bringing the kids over to say Happy Mother's Day to our mother and spending some time there. We have to spoil her a little bit more today. Maybe we'll.
I had my daughters bring their grandmother's flowers on Friday, so I'm way ahead of you on this.
Well, I went over on Saturday.
Said they were from you too, but I didn't.
It's okay. I went over on Saturday. One of my kids went over there on Saturday and ate with them for Saturday lunch. And then I'm sure today we're going to have something together also. So thank you very much again, Solomon. I'm just going to take you off. So just to say goodbye to everybody here. Thank you all for joining again. We had a great time today talking about the Karen Reed case. We have the live stream tomorrow, live streaming the trial, continuing with my my real-time analysis. And we're going to be starting again tomorrow at 10 a.m. 10 a.m. tomorrow, so you get to sleep in a little bit tomorrow. I, of course, have to get up early because now that I have an extra hour, I got to catch up on a lot of stuff. So I have to utilize every single minute of every single day these days while the Karen Reed case is going on, because I actually still have some cases that I'm handling. So that's going to be it for now. Thank you all for joining. We'll see you tomorrow. We'll see you on the recaps. If you haven't yet, subscribe, like the video, and we will see you all later. Thank you all for joining.